Have it. Question for short debate, offence of misleading the public, Baroness Jones and Woolsey.
My Lords, what a small, select, charming little group we are to discuss a topic that could be, it could feature quite high in news media later, because I think it's an issue that the public will actually care about. This bill has rightly been recognised for its proposed duty of candour, but there's another provision within it, less understood and yet actually vastly more consequential: the creation for the first time in modern democratic history of a criminal offence of misleading the public. It provides that where a public official, including our very own Prime Minister, knowingly or recklessly deceives the public on a matter of significant public concern, and if that deception is proven to the criminal standard, a prison sentence of up to 2 years may follow. In short, the Prime Minister is proposing to criminalise lying in politics for the first time, and he's leading by example by applying it to himself. This has never happened before, and I do congratulate the government for being brave and decent enough to criminalise lying by their own ministers. I think that's a very big step. Now, this bill has commonly been called the Hillsborough Law because of the stadium crush in 1989 in Hillsborough, Sheffield, in which 97 Liverpool supporters were unlawfully killed, followed by years in which police and other officials advanced misleading accounts that falsely blamed the victims, deceived families over the pain their loved ones suffered before death, and obscured institutional failings. The sustained campaign by the bereaved families for truth and accountability led to the Hillsborough Law Now movement and to the introduction in Parliament of this bill. It is intended to impose a duty of candour, a statutory duty, and criminalise serious deception by public officials. It's worth noting that the inaccurate account by Sheffield Police has never been corrected, and that is something the government should resolve. Amongst others, the Hicks family lost 2 daughters, and they and other still grieving families deserve the truth. This bill will correct an inconsistency. For centuries, we've criminalised deception in almost every professional sphere, except for some politicians. Fraud is an offence, perjury is an offence, false advertising is unlawful. Under consumer protection legislation, tradesmen may not mislead the public about serious matters. In finance, in commerce, in the courts, in taxation, truthfulness is not optional, it's legally enforceable. We already accept under the Representation of the People Act that dishonest statements about a rival candidate during an election may be criminal. So the principle that deliberate political falsehoods can be legislated against isn't novel. It has existed for decades without overwhelming the courts or extinguishing debate. No equivalent statutory standard has governed broader public claims made by politicians. That anomaly can be set against the collapse of public trust. The Ipsos Mori Veracity Index once again ranks politicians amongst the least trusted professions in the UK. That distrust weakens democratic consent. It discourages civic participation. It feeds a corrosive cynicism that democratic institutions cannot be trusted and that Parliament is full of liars. It makes the lives of members of the Commons and the Lords much harder and doubtless impacts on our well-being as well. But this bill does offer some hope. This proposed new offence of misleading the public attempts to respond to that crisis not by criminalising opinion, not by silencing debate, not by punishing error or failed prediction, but by addressing something narrower and more serious: deliberate or reckless deception about matters of significant concern to the public, proven beyond reasonable doubt. Some have raised concerns about free expression. Those concerns deserve respect, but the offence, as drafted, is confined to intentional or reckless deception. It does not criminalise political disagreement. It does not capture advocacy. It does not police rhetoric. It does not apply to anything said within Parliament, as privilege is still in place. It only targets proven deceit elsewhere, such as online, on television, on radio, and at events. And I hope that this narrow definition will stop people with expensive lawyers from launching malicious legal cases in the hope of silencing legitimate criticisms. In short, this provision affirms a simple democratic proposition. Those who exercise public authority should not be permitted to lie to the public with impunity. So far, so good. And yet, the following exemptions have been brought to my attention by campaigner Marcus Ball of ExecProsec, who is working with Jennifer Nadell of Compassion in Politics and with Luke Meyer MP from the other place. As currently drafted, that proposition excludes some parliamentarians. Civil servants would be bound by this, police officers would be bound, members of the armed forces would be bound, NHS staff would be bound, and government ministers, even the Prime Minister, would be bound. But backbench members of Parliament and members of your Lordship's House would not. The shadow cabinet would not. The opposition in its entirety would not. There may be procedural explanations for excluding peers and backbench MPs, or there may even be technical constitutional arguments, but I just wonder what the public is going to think. They will see a law that criminalises deception by nearly every category of public official, except the very people who are making this bill become law. They will not be persuaded by constitutional nuance. They will draw a much simpler conclusion. If Parliament legislates a requirement not to lie for others while reserving exemption for itself, the perception will be that we parliamentarians are hypocrites. That perception will endure each time the offence is invoked, each time a prosecution is considered, each time accountability is pursued, each time any parliamentarian is accused of being dishonest. The public will be reminded that Parliament chose to criminalise lying by almost all public officials apart from themselves. Equality before the law is the foundation of democratic legitimacy. If nurses, teachers, civil servants, ministers, even the Prime Minister are to be subject to this standard, it's impossible to persuasively justify a position in which members of either House of Parliament are not. Surely those who make the law should be subject to the same standard of honesty that we, as legislators, impose on others. This House has long seen itself as the guardian of constitutional principle. We are uniquely placed to consider not only how legislation functions in the courts, but how it will be understood by the public. I'm concerned that if we don't apply this law to ourselves, we will be causing reputational self-harm. We are legislators, we pass laws that relate to everyone else, so why not to us as well? To conclude, I would like to ask the Noble Lady the Minister a couple of questions. I sense the government probably won't accept what I'm saying, but I wonder if she would meet me at a future date to discuss this, perhaps with one or two lawyers along who can argue more persuasively than I can. But I do want to ask why members of Parliament, in both houses, are excluded from Clause 11. And will the government now give serious consideration to removing that exclusion so that this bill may stand as a testament to integrity rather than a monument to hypocrisy? I beg to move.
I begin by thanking and congratulating the Noble Baroness Jones in bringing forward this important debate. It's a good question. I agree with her that the Public Office Accountability Bill should be welcomed, but I will wait until our second reading in this place before talking to the wider merits of the bill. My Lords, few matters strike more directly at the moral core of public life than the question of honesty. And few touch this House more directly than the standards we set for ourselves. Clause 11 of the Public Office Accountability Bill creates a new criminal offence, as we've heard, where a public authority or official acting in that capacity intentionally or recklessly misleads the public, knowing or reasonably expected to know that such conduct is seriously improper. The intention, as I understand it, is to ensure that those exercising the powers of the state are held to the highest standards of truthfulness. It would apply to government departments, to local authorities, to the police, the NHS, to schools, and others exercising public functions. And yet, as we've heard, both members of both Houses of Parliament are to be excluded. The government's reasoning is that the clause is aimed at those who wield executive authority rather than those in representative or political roles. But is that distinction defensible? Does this fly in the court of public opinion? Why should accountability in public life be limited only to those who administer the state rather than those who make its laws or shape its policies? To be a member of either house is to possess a particular form of public authority, the authority of trust. As recent events relating to Lord Mandelson have shown, parliamentarians are not above the system. We are the system in the eyes of the public. Our words, our votes and our conduct influence government action, policy direction and public belief. That is power by any reasonable definition, and it is power that depends entirely upon trust. And as the clause stands, it applies, yes, to a government minister acting in an executive capacity, but in that case, ministers face a legal duty not to seriously mislead the public, but not their opposition shadow. That asymmetry is quite frankly bonkers and unfair on political incumbents. We are in an age of disinformation. Elected politicians who consistently, deliberately and cynically mislead the public should be subject to criminal sanctions in extremis. Outside the protections rightly offered by parliamentary privilege, should we not be prepared to hold ourselves to account when serious or repeated dishonesty on matters of public concern causes demonstrable harm? The damage caused by misleading the public goes far beyond a single misstatement. It corrodes the foundations of confidence upon which democratic governance rests. It also creates fertile ground for those who thrive on distrust and resentment, for the bad faith actors who see cynicism as a political opportunity. We've seen again and again how false narratives can take hold and persist. Hillsborough, the infected blood scandal, the Horizon cases, more recently the Partygate affair, each has shown how misinformation and evasion can compound tragedy, turning mistakes into long-term injustice. The bill bears the Hillsborough name advisedly. It reminds us that misleading the public is not a victimless act. The evidence of eroded trust in politicians in this context is stark. The 2024 British Social Attitudes Survey found that 58% of people almost never trust politicians to tell the truth. 4 in 5 said they were dissatisfied with how they were governed. The Electoral Commission's 2025 findings were similar. Only 14% expressed trust in politicians. According to the Constitution Unit, being honest ranks as the single most desirable quality in a parliamentarian, and nearly 3/4 of respondents support the removal of MPs who lie. In that context, the amendment already tabled in the Commons by my political friend, Luke Meyer MP, deserves serious consideration. It would extend Clause 11 to members of both houses in a proportionate and carefully safeguarded way, not to stifle political disagreement, as Baroness Jones has said, but to make clear that those who knowingly and deliberately mislead the public cannot do so with impunity. That principle, I believe, commands widespread public support. And to do otherwise confirms exactly the perception that has done such damage to trust in political institutions, that there's one rule for us and another for everybody else. That sentiment has helped drive the rising populist tide that every democracy now faces. A mention of populism triggers me to say something about valid concerns about freedom of expression. These are understandable, but I think in this case misplaced. The threshold in Clause 11 is intentionally high. It is directed only at conduct that is serious, significant, and harmful. The clause includes a reasonable excused offence and would require a demanding evidential standard. It's not about slips of the tongue, robust political rhetoric, or contested interpretation. It is about substantiated, deliberate dishonesty causing real harm. In practice, prosecutions would likely be rare, but the deterrent effect of the law, the statement of principles it represents, is powerful. So some may observe that the common law offence of misconduct in public office that we've been hearing quite a lot about lately already covers such ground. In theory, yes, but in practice, this common law offence is notoriously ill-defined and difficult to sustain. Clause 11, however, carefully drafted, offers a clearer, modern test for the same fundamental idea, that the abuse of public trust is, at its most serious, a criminal matter. So, my lords, this is, in my view, about leading by example. We cannot credibly legislate for honesty in public life while exempting ourselves. If we do, we risk deepening the very scepticism this bill seeks to repair. The British public are remarkably forgiving of error. They are far less forgiving of hypocrisy. A parliament that will not hold itself to its own standards invites precisely the accusations of entitlement and complacency that have weakened respect for institutions across the democratic world and fuel the growing belief that we are an entitled, self-serving elite. The restoration of trust will never come solely through codes of conduct or ministerial guidance. It will come through action, through showing that no one, however senior or unelected, is beyond accountability. Extending Clause 11 to members of both houses with proper safeguards for privilege and free expression would mark a principled step in that direction. So, my lords, if honesty in public life is to be more than a slogan, we must be prepared to bound ourselves by it in law and not just in aspiration.
My lords, I declare my interest as the director of the Free Speech Union, which may well end up defending people as a result of the Public Office Accountability Bill, given that it creates a new speech offence. That offence, as we've heard, is that of misleading the public. A public authority or public official commits an offence if, in their capacity as such an authority or official, A, they act with the intention of misleading the public or are reckless as to whether their act will do so, and B, they know or ought to know that their act is seriously improper. The problem is not that MPs and peers are immune to being prosecuted for this offence, but that the carve-out is not large enough. According to my reading of the bill, MPs or peers acting as public officials, i.e. as ministers of the Crown, would be liable. That, my lords, is a gold-embossed invitation to the Jolyon Morms of this world. It will unleash a wave of politically motivated lawfare. Is that really what we want? The new offence of misleading the public is, as the noble lord just pointed out, intended to replace the offence of misconduct in public office. And let's not forget that attempts have been made by political activists to bring private prosecutions against their opponents for committing that offence. For instance, in 2019, an outfit called the Brexit Justice Group brought a private prosecution against Boris Johnson for misconduct in public office because he had, according to them, knowingly misled the electorate in the EU referendum campaign by claiming leaving would bring a bounty of £350 million a week. An obviously vexatious case, my lords, but a magistrate issued 3 summonses against the then Prime Minister before the case was eventually thrown out in the High Court. Should this bill become law, we can look forward to a slew of similar cases. Rachel Reeves, for instance, might find herself in the dock for claiming she wouldn't raise taxes on working people, while Ed Miliband could have his collar felt for promising household energy bills would fall by £300. If the bill is amended along the lines the noble lady Baroness Jones wants, wouldn't her party's candidate in the Gorton and Denton by-election find herself in difficulty, assuming she becomes an MP? During her now infamous campaign video in Urdu, released a few days ago, she said of Reform UK, quote, "They want to put higher taxes on people who were born abroad." That, my lords, is misleading, to put it at its most charitable. The noble Lady Baroness Jones said there are safeguards in the bill to prevent private prosecutions. But what's to stop members of the public bringing judicial reviews against the police for not prosecuting politicians for misleading the public? The Free Speech Union recently defended an SNP activist and the editor of a blog called Wings Over Scotland, who had supposedly said something transphobic on social media. A trans activist called Lindsay Watson tried to sue Greater Manchester Police for not prosecuting him. I'm happy to say he failed, but that's not to say others won't attempt to sue the police for not arresting lying politicians. But I don't want to see Hannah Spencer behind bars for misleading the public any more than I do the Chancellor of the Exchequer or the Secretary of State for Energy Security and Net Zero. Candidates campaign in poetry and govern in prose, my lords, and if they do fail to keep their promises or traffic in obvious mistruths, there is already an adequate mechanism for punishing them, namely the ballot box. So rather than extend the scope of this bill to include MPs and peers, let's limit it to make sure that members of both houses, in whatever capacity, are properly excluded. Indeed, I go further and urge the government to amend the bill to exclude civil servants too, and not just those working in the intelligence services. As a recent piece in The Economist pointed out, making Whitehall officials liable for prosecution for misleading the public could have disastrous unintended consequences. It will mean fewer civil servants willing to take responsibility for decisions or giving ministerial advice, more decision-making by committee to dilute liability. Rather than provide ministers with timely, sensible advice, they'll mitigate the risk of a prosecution down the line by obfuscation and delay. To quote from The Economists, ministers complain that the civil service is bogged in a sludge of slow decision-making, but officials will have an incentive to take more detailed minutes, keep more records, and give risk assessments even lengthier consideration to ensure against future court challenges. I'm reminded of the effect of the Freedom of Information Act 2000. Rather than lead to greater transparency when it comes to official decision-making, it just resulted in MPs, peers and Whitehall officials abandoning email in favour of WhatsApp, with disappearing messages switched on. Less transparency rather than more. My lords, the intentions behind this bill are undoubtedly good. The families of those who died in the Hillsborough tragedy deserve to hear the truth from public officials, including those, particularly those, testifying to various inquiries. But candour is something it's hard to legislate for. And to pretend that this bill will, quote, once and for all end the culture of cover-ups and hiding the truth, unquote, as the Labour manifesto promised, is, I'm afraid, just another example of misleading the public.
Could I possibly thank the noble lord for raising the profile of our candidate in the Gorton and Denton by-election? That's very kind of him.
I, too, welcome the obtaining of this debate by Baroness Jones, and I want to return, as I think we often should, to the actual question in the debate. We shall have plenty of time to look at the bill when it gets here. We're not on the bill, we're on this very narrow point. Narrow though it is important. And it seems to me that although I think that presently that what the government has proposed, namely excluding MPs and peers, is probably right because it is the government and the executive that are dealt with in the scope of this bill, it is worthwhile considering what the implications of this are. And I think we can take two things by way of some help in examining the question, because the acuteness of this issue will arise primarily when we get close to an election or when political tensions are high. And it's quite interesting to see what we did in the Representation of the People Act, or to go back to the time it was originally enacted in 1895, in distinguishing between untruths in relation to people's personal characteristics and untruths in relation to all other matters. And it is remarkable, it seems to me, that that distinction, which, looking at the debates in 1895, was one that was very carefully made, has stood us in good stead because we addressed a particular problem in elections. When you look at the debates, you can see what was worrying politicians in 1895. One was worried about the fact that during an election he had been on a bench of magistrates and was said to have sent a man to prison for a month with hard labour for stealing 3 penn'orth worth of oats he had dissented from the decision of the others. Another was accused of his yacht being used to poach salmon with a net on a Sunday in Scotland. And it was this very concern that untruths were being told about people's personal characteristics for which there was no effective remedy because you couldn't bring an action for slander during an election. And therefore, in 1895, it was decided one ought to focus what was the problem, what was the remedy, and should it be enacted. It was enacted then and has been reenacted successively as recently as the 1983 legislation. And why that has been restricted in this way, looking at the case law that has elucidated these provisions, it seems to me that what Parliament then thought, and which is to my mind a very tenable position, that whereas it's wrong to be allowed to tell lies about someone's personal characteristics, because it's very difficult to disprove those, do you leave the good sense of lying about politics to the public? And that was a question that, or an issue that has served us well, I would think, for over 125, 130 years. But the question is, should we continue that distinction? And I think it's useful to look at a second matter, which is the proceedings in Senedd Cymru, where in relation to elections in Wales, it is proposed that there be an offence very similar to what is envisaged in the bill, applicable during elections, namely telling untruths of any fact or matter completely. And the report of the examination by the Senedd Committee is useful reading because they had evidence from the Electoral Commission, from the Bar in Wales, from Transparency International, and from Professor Holder and others, in relation to the problems that you create by having a wide-ranging offence of this kind. Now, it seems to me the way forward is to look and see what is the problem with those in this House and in the other place, and is there a remedy that should be brought, and in what circumstances? Because I think the one thing that would be very, very undesirable is to create a huge amount of potential for people to complain to the police, to say X is lying, Y is lying about this, and seek to engage in political prosecutions of that kind. I think that is a real worry, but I go this far in supporting Baroness Jones, that we simply ought to look at the difficulties, look and see what the problem is, but it is a difficult problem on which there is an awful lot of experience and we need a proper examination. But on what I have read so far, I regret to say that I agree with leaving their lordships, or should I say your lordships, including myself, and others out of the scope of this bill, because there's a logic to confining this to the executive and not opening the door to lengthy, politically inspired prosecutions. But it's a question that should be examined, and that's why I'm so grateful to Baroness Jones for raising this very difficult point.
My Lords, I join with everybody in congratulating and thanking the Noble Lady Baroness Jones for raising this issue and for the powerful and eloquent way in which she opened it and presented her arguments. And as we've heard, the question the debate raises is whether it's right that Schedule 2 of the bill would exclude parliamentarians from both houses from the definition of public authorities and public officials who might be guilty of an offence of misleading the public under Clause 11. And I agree also with the noble and learned Lord Thomas, who described this as a very difficult issue that was not going to be simple to determine and that required a great deal of consideration. On the one hand, as the noble Lady Baroness Jones pointed out, the exclusion of parliamentarians from the ambit of this offence could well be perceived by the public as putting parliamentarians above the law. Some Labour MPs have expressed that view in the House of Commons and the media, and Baroness Jones gained powerful support from the speech of the noble Lord Knight of Weymouth, who also made the point, which is of considerable significance, that ministers acting in their executive capacity would be liable to be prosecuted under this offence, whereas their shadows, the shadow ministers, would be in an entirely different position. On the other hand, if the exclusion were removed, then it could be said that peers and MPs might be deterred from speaking freely on important issues. And that is the basis upon which parliamentary privilege is founded. The reason given in the explanatory notes to the bill for the exclusion of parliamentarians is, and I quote, in recognition of long-standing conventions around the independence of the judiciary, I might say are also excluded from offences under Clause 11, and Parliament's ability to regulate its own affairs. And the notes continue, these institutions have their own processes of establishing and enforcing ethical standards. No more detailed explanation was given on behalf of the government in committee by the Minister at the MOJ, Alex Davis-Jones MP. He referred only to long-standing conventions of self-regulation and independence. For my part, I am not sure that is a convincing response. In my view, the mere existence of long-standing conventions should not prevent Parliament from examining those conventions and, if necessary, legislating to overturn them. So I have a great deal of sympathy with Baroness Jones' position. She rightly points out that the Clause 11 offence is directed not at innocent mistake or honest disagreement, but at deliberately or recklessly misleading the public when the accused knows or ought to know that their act is seriously improper. That is a pretty heinous wrong, and one that the bill is rightly determined to prevent and penalise. The threshold for conviction is a high one. So why, she asks, should parliamentary privilege and MPs and peers' freedom of speech get in the way of that worthwhile aim, against the background that we have seen of unacceptable institutional cover-ups and outright dishonesty by some official bodies, which this bill is intended to address? But, my Lords, my concern with Baroness Jones' position is not principally that without the exclusion, parliaments would in fact, in practice, be prosecuted for this offence, that parliamentarians would. My concern is rather that without the exclusion, parliamentarians could be threatened publicly and in correspondence with prosecution, and that the threat of attempted prosecutions could deter MPs and peers from speaking their mind openly and without fear of the consequences. It is in that context that the protection of parliamentary privilege is genuinely an important democratic protection. It is true that under Schedule 3, Clause 2.2, proceedings for a Clause 11 offence could only be brought with the consent of the DPP. But nevertheless, the whole process of investigation and consideration and the threat of prosecution could have a chilling effect on parliamentarians and parliamentary debate. So it's not just freedom from prosecution that is important, it's also freedom from the threat of prosecution. I'm reminded of the argument around SLAPS litigation, SLAPS standing for the obscure description strategic lawsuits against public prosecution. But as we all know, SLAPS are unmeritorious actions, threatened or brought, often for alleged defamation, by powerful or wealthy individuals generally, or organisations, to frighten off critics who would attack them in the press or elsewhere. And SLAPS are used as a form of oppressive censorship of investigative journalism and legitimate criticism, which we are rightly attempting to regulate, control, or penalise. In the context of this bill, a parallel argument was advanced at second reading in the House of Commons by the Conservative MP Mike Wood. He foresaw a risk of parliamentarians being subjected to what he called politically motivated lawfare, and I note that that was an expression repeated by the noble Lord Young of Acton, which the exclusions are designed to prevent. I'm bound to say I found some of the noble Lord Young's examples a little overstated at times, but nevertheless it's a point that is worth making. I found the argument of the noble and learned Lord Thomas of Cumgeath very persuasive, including his distinction, which may not be directly in point but is helpful, between lying about politics and lying about personal characteristics, and that distinction is illuminating. My lords, we should not be so complacent as to believe that parliamentarians would be so immune to threats as always to stick to our guns in the face of them. Parliamentarians expect and welcome criticism and argument and disagreement. But the threat of prosecution for speaking their minds is not a legitimate hazard of parliamentary life, I suggest. And at worst, it may drive some to trim or curtail their arguments, even if not abandoning them. So on the whole, and with some hesitation, I've come down on the side of parliamentary privilege and in favour of the exclusion that is written into the bill, despite the very powerful arguments set out by the noble lady, the Baroness Jones, and the noble Lord Knight of Weymouth, and others.
My Lords, I am grateful for the noble lady Baroness Jones for providing the opportunity for noble lords to raise a matter of deep and real public interest. The exclusion of members of this House and of the House of Commons from Clause 11 of the Public Office Accountability Bill is a topic which touches on both constitutional issues and those which relate to public trust. The bill engages long-standing concerns about transparency in public life. It will impose a duty on public authorities and public officials to act with candour, transparency and frankness, and to maintain ethical conduct within all parts of their authority. It creates offences for those who in that capacity, and I emphasise the word in that capacity, mislead the public and in relation to the misconduct of persons who hold public office. The Hillsborough family's campaign for accountability has been one of the most powerful calls for reform in recent decades. It is right that we act on their concerns. Here I declare an interest. I acted in some civil claims subsequently on behalf of South Yorkshire Police, but at a later date for victims who sued their solicitors who'd settled their original claims for too little. I have also represented a health authority in a public inquiry against a dishonest consultant, so I know and have practical experience of what dishonesty and cover-ups can mean for the victims. The new offences will apply when a public authority or official acting with intention or reckless disregard commits improper acts that mislead in respect of matters of significant public concern. But MPs and peers do not, by virtue of that status alone, and we must remember that, act as officials. By Schedule 2 of the Bill, public authority means a government department, a minister of the Crown, the Scottish ministers, the Welsh ministers, Northern Ireland devolved authority. So individual office holders and their departments, when acting, are within scope. It is only when acting personally in a purely parliamentary capacity that an MP or a peer will be immune. This debate raises the interesting and difficult question, when, if ever, should MPs and peers be guilty of the criminal offences contained in this bill? Neither House of Parliament will, for that purpose, be a public authority. This reflects long-standing constitutional conventions of Parliament's self-regulation and independence. Parliamentary privilege and constitutional autonomy are vital. They must not be compromised. Article 9 of the Bill of Rights, 1689, remains a cornerstone of our constitutional settlement. It provides that freedom of speech and debate in Parliament, and I quote, ought not to be impeached or questioned in any court or place out of Parliament. Article 9 safeguards the core functions of this House and the other place in debating and scrutinising the government without fear of legal sanction. Those who abuse parliamentary privilege are susceptible to punishment and expulsion by Parliament. The problems with the Hillsborough and infected blood scandals stem from cover-ups by those acting in official positions, whether as ministers or officials, and I'm not suggesting anyone in particular here, but they were in positions of authority. The noble and learned Lord Thomas has explained some of the hazards which might arise from going beyond the bill, and the significance of the Representation of the People Act, for example. My noble friend Lord Young of Acton has explained other risks. Lord Marks has rightly highlighted the danger of the mere threat of proceedings to what people may then be prepared to say in either House of Parliament. So Article 9 rightly protects proceedings in Parliament. It does not protect conduct by individuals outside those parameters, those formal proceedings. Nor does it provide immunity from the criminal law for conduct outside parliamentary debate. See the expenses scandal, where at least one MP attempted to run the argument but failed in the courts. The scope of parliamentary privilege is carefully constrained, and rightly so. My Lords, Parliament should be very cautious, lest any words spoken on the floors of either House or in its committees are put at risk of being caught by criminal offences or indeed civil actions. The threat of prosecution would have a chilling effect on robust debate, which is the essence of parliamentary democracy. An authoritarian government with majorities in both houses, or any mischief maker in either house, or any outsider might raise specious allegations for bad motives, or just out of ignorance. The fact that the member in question might ultimately be acquitted, whether in the criminal courts or the civil courts of wrongdoing, will not have prevented exposure to frightening pressures. Our legislators must not be so exposed. The Bill of Rights is a bulwark. History is on its side. Some members in the other place, as we have heard, have suggested that extending the offence to MPs and peers might improve public trust and perception. Amendments have been tabled from some MPs to bring members of Parliament within the scope of the offence. That would be a grave error. MPs and peers acting as such do not make decisions on behalf of the state. They are not ministers or officials. Their misconduct, if and when it occurs, will be addressed by Parliament, and we've had examples in the recent past. Parliament does and will police its members. No one else should, when acting within the bounds which I have set out. My Lords, we on these benches believe that creating a criminal offence would be wrong. But we also recognise that the exclusion of Parliament from the offence, if it is not properly explained to the public, risks sending the wrong message. And it's not an easy topic to explain in plain and simple terms to a wider public. Accountability and integrity in public life must be strengthened and supported, and public trust in our institutions is frankly fragile at the present time. But the way to hell is paved with good intentions, so beware, the remedy will be worse than the cure, than the disease. Given these considerations, I ask the noble Baroness, the Minister, what consideration has the government given to alternative models to ensure meaningful accountability without infringing on this privilege? Does the government believe the current system of parliamentary sanctions alone is sufficient and effective? Third, what further parliamentary sanctions might be of value? And fourth, what steps will the government take during the currency of this bill to explain these important principles of our Constitution?
My Lords, it's customary to begin by thanking the noble lady Baroness Jones of Molescombe for securing this debate. But I'm sure she would agree with me that actually I should start by paying tribute to the victims of the Hillsborough disaster and their families. And in doing this, I want to make it clear that the victims and bereaved must always be front and centre of the government's mind as this bill makes its long overdue way through Parliament. I hope your Lordships will understand what I mean when I say that this bill is not just about justice for Hillsborough victims and families and those of the other disasters, but it determines what kind of a society we are. Do we protect vested interests, or do we believe in the importance and rights of and protections for our fellow citizens as individuals? And to that extent, I entirely understand the points made very forcefully by the noble lady Baroness Jones and my noble friend Lord Knight. The noble lady and I had a very short discussion yesterday when she explained her concerns to me, and I'm grateful to her for that. And I hope she knows that my objective in this matter is not to make partisan points or to be stubborn about legislation, but to make sure that as we go through the process of introducing a new law, we get it right. And by right, I mean that the law captures the behaviour that we think is so egregious that it merits being criminalised, whilst not trespassing on other important issues which will include convention rights. So by securing today's debate, the noble lady and all the other members of your Lordship's House who have spoken have given the government food for thought, and I have treated the contributions as everybody as in effect being those of critical friends. My Lords, the offence of misleading the public is a brand new offence contained in the Public Office Accountability Bill. And your Lordships will, as was said by the noble and learned Lord Thomas of Cumgead, have the opportunity to scrutinise it fully when it's sent to us from the other place. My intention today is to explain the policy reasoning behind the government's decision to limit the offence to the executive rather than extending it to all MPs and peers. In order to do this, I need briefly to outline what the bill in general, and this clause in particular, is intended to do. The government's clear that what happened following the Hillsborough disaster must never happen again. In that case, police lied, they changed witness statements to protect their reputations. The bereaved families from Hillsborough, and indeed too many other examples over many years, faced an inquest process with no funding for legal representation, and all of this was underpinned by a lack of duty of candour. So the bill contains a powerful new package of measures to address these failings and others such as the infected blood and Horizon scandals. Now, as part of the measure, this bill creates not one, but in fact 4 new criminal offences. And they fall into 2 groups, and there's plainly some level of misunderstanding about this, articulated perhaps most clearly by the Noble Lord Young of Acton, to whom I owe an apology because in a letter the other day on the Crime and Policing Bill, I addressed him as the Lord Young of Action, though perhaps you won't mind too much. The first group of these 4 offences is 2 offences to replace the common law offence of misconduct in public office, which is going to be repealed. The first of those new offences is committing seriously improper acts, and the second is breaching the duty to prevent death or serious injury. And these new offences broadly replicate the effect of the common law offence, and they have a very wide reach. They cover a lot of the behaviour, not just of the kind that was seen at Hillsborough, but a much broader range. For example, misconduct in public office has in the past been used to prosecute for offences such as corruption in public office, and that is what these 2 new offences are intended to replicate. The reason we're replacing it is because there was a lack of certainty with it, and one of the issues with the old common law offence is a lack of a list of those to whom the law applied. So to deal with that, those 2 new offences do have a list, and both of those 2 very broad offences do apply to MPs and to peers, as well as a number of other public office holders, including judges. But secondly, we have created another 2 new offences, which are completely separate from the old misconduct in public office. And they were designed specifically to deal with a narrower range of circumstances and to deal with this situation that has arisen in these large-scale disasters. And these 2 new offences are, first, breach of the new duty of candour, and secondly, the offence of misleading the public contained in Clause 11, and it's only this one of these 4 new offences with which we're concerned today. My Lords, as I've already said, this offence is designed to be a much narrower offence than the ones designed to replace misconduct in public office, and it was designed specifically with what happened at Hillsborough in the front of our minds, and the reason is this. As the scale of the disaster at Hillsborough was becoming apparent, the police lied about its cause, saying that Liverpool fans had broken into the stadium. But as we now know, as the Taylor inquiry uncovered, in fact the main reason for the disaster was the failure of the police control. So this new offence is aimed squarely at those who intentionally or recklessly aim to mislead the public and cover up the truth. It's intended to capture only the most serious instances of public officials or authorities misleading the public. So an example might be a chief executive of a hospital instructing the staff to lie about a major incident in order to avoid criticism of the hospital. It is not intended to apply to instances of accidental or inadvertent misleading. And to reassure the Noble Lord Young, prosecutions can't be brought without the consent of the Director of Public Prosecutions, specifically to avoid vexatious private prosecutions. He mentioned judicial review, but the doorway into a judicial review is a narrow one. It's a very restricted set of circumstances, and it's subject to a permission stage from the High Court. My Lords, the Government thought very carefully about to whom this offence should apply. It does apply to public officials and public authorities, so it captures those working in government and the wider public sector who take decisions on behalf of the state. So that includes ministers and other politicians in executive roles, but not MPs and peers. And our thinking is this: Parliament has a unique role in our society. Parliamentarians are responsible for legislating and scrutinising legislation, holding the government to account. And as well as this, MPs are responsible for representing their constituents. But individual MPs and peers do not directly take decisions on behalf of the state, nor do they have access to the kind of government information that would be available to ministers. And for that reason, we've come to the conclusion that it would not be appropriate to extend the offences in the bill to all MPs and peers, and they're not extended to judges either. So you have the wide group designed to replace misconduct in public office, applies to backbenchers, the opposition, so on and so forth, and the judiciary, and this narrow offence designed to basically cover those who take decisions. Of course, the government agrees that misleading the public in any capacity is not acceptable. There should be consequences for parliamentarians who do so. But, my lords, this new offence is not the appropriate vehicle for regulating political speech. Parliament has its own arrangements for ensuring accuracy and truthfulness in proceedings, including processes for determining if MPs have misled the other place, and it's for the House of Lords Procedure and Privileges Committee to consider any instances where a member of your Lordship's House is alleged to have misled the House. This reflects the important principle that parliamentary proceedings are rightly privileged and cannot be questioned in a court of law. So each House is responsible for determining the right sanctions when it's alleged that someone has misled the House. Members of both Houses must also act in accordance with the Nolan principles in all of their public functions and the very high standards expected of public office holders conducting themselves with honesty and integrity. My Lords, it is for each House to determine the procedures for investigating and sanctioning those who break the rules. My Lords, the Government is confident that the scope of the new offence, combined with the existing arrangements and the codes of conduct for parliamentarians, strike the right balance between capturing the most serious wrongdoing whilst not infringing the tried and tested procedures that govern all of your Lordships and all those in the other place to ensure that we conduct ourselves to the highest standards. But this has been an interesting and an important debate. I will, of course, meet the noble lady and any lawyers she wants to bring with her, and indeed any other members of your Lordship's House who would like to discuss this further.
My Lords, we will allow a moment for the Chamber to rearrange itself before the next business.